One moment, please. Okay, we're on the record.
Mr. Quinn, are you there?
Yes.
Can you hear me?
Yes.
Could you point your camera at yourself, please, if there's a way to do that, so we can see you during the hearing? We'll give you a second here to get that organized if you can. Is that as good as we're going to get, you think, Mr. Quinn?
Yes, sir. Sorry.
All right, that's okay. And can you also, Ms. Gasson, can you also hear me?
Yes, I can, Your Honor.
Excellent. So we are here, welcome, I should say, to the single justice session of the appeals court. I'm Judge Rubin. And the case we are hearing this morning is number 23J288, Gasson versus Quinn. And the way this will work is each of you will get 10 minutes to present your argument. You don't have to use all of it, or you can. And because you are representing yourselves, if there are issues that we need to address that might go a couple minutes longer, I will be flexible about that. There will be a timer that will appear in the box that currently says Massachusetts Appeals Court, and it will count down from 10 minutes. And when it gets to 0, it'll turn red, and I'll tell you your time is up. This is, of course, an appeal from the denial of the motion to waive the appeal bond in this case. And it is brought here by Mr. Quinn. And therefore, and I should say to both of you, I know how difficult it must be to appear in court or by Zoom in court even for people who are not lawyers. It may be intimidating to talk to a judge at all. And of course, you lack the legal training to maybe couch things in legal terms. But try to relax, and I'll hear what you have to say, and I may have questions for you, and we'll see what we can sort out. So having said that, we will hear first from you, Mr. Quinn, on the question of why the appeal bond should be waived. And I will say this, there are two showings that have to be made for the appeal bond to be waived. And the first is indigency, and the second is a non-frivolous issue for appeal from the judgment itself. And I am going to, I don't think it's contested that you meet the qualifications for indigency, Mr. Quinn. So you may want to focus your argument on the second prong, which is non-frivolous grounds for appeal from the original judgment. And with that, you may go ahead.
Your Honor,
I'm sorry, who are you?
Your Honor, I'm a neighbor.
Yeah, well, you can't speak for him unless you're a member of the bar, are you?
No, I am not.
Well, you can't speak for him. Only a lawyer can represent a person. He's
Well,
going to have to talk for
This is
himself.
this is the problem, sir.
Can we
the
pause the
anxiety-
clock? Let's turn the clock off, actually, if someone in the clerk's office can do that. And we'll start it again in a minute. What's...
Yeah.
Tell me your name, first of all.
I'm a friend of Chris.
Yes,
And-
I'm
and
asking for the record. I'm sorry, sir. I'm asking you for the record for your name.
My name is Carl
What's your last name?
Fucillo.
Okay, go ahead, Mr. Fucillo.
Yes. The anxiety of the court and what you said, the intimidation. Chris, without question, is in almost a small state of shock. He doesn't have the ability to talk and function because he's not familiar with any court proceedings.
Of course.
He's requested some type of legal counsel provided by the court because with his state of shock, he really isn't comprehending or understanding what procedure is going along and what he should do. He wants to comply with the court's decisions, but he wants to understand what's going on. He's asked the court, according to him, to request and to obtain for him some type of legal counsel to which he does not have. And this is his only request, sir, is if you can get him legal counsel, he will gratefully go through the process
Yes,
of
of
the
course.
law.
Now, this is the difficult thing. Although in criminal cases, people are entitled to a lawyer appointed by the government if they can't afford a lawyer. In non-criminal cases like this, there is no provision for that, at least so far as I'm aware. I also have to say I haven't seen a motion in our court, at least. Maybe he made that request in the trial court. So that's not, so far as I'm aware, and when we're done with this, I'll check, but so far as I'm aware, we don't have the authority, or for that matter, funding or a statute allowing us to appoint a lawyer. And I understand how terrible that is. And there are, of course, also legal services clinics available at places like law schools, BC, BU, Harvard, Northeastern. I think they all have clinics that some of which are probably designed to assist people with, Suffolk has one, I think for sure, to assist people with housing court cases. But for today's hearing, at least, I can't appoint a lawyer and you can't represent Mr. Quinn. He doesn't have to argue. It is his time and he's allowed 10 minutes. But I mean, I understand if he doesn't want to make an argument, it makes it, he hasn't presented anything to us so far. So it makes it difficult to act in his favor for it even to be possible without knowing something from him about why this bond should be waived. So that's
Your Honor, if I could
no,
be,
I'm sorry. Well, all right. Yes, Ms. Gassett.
no problem. I just wanted to be fully transparent and let you know that I am a member of the bar, even though I am acting as pro se in this matter.
Oh, I didn't know that.
And Mr. Quinn has appeared at the trial. He appeared at the housing specialist, and he was able to testify on his own
I'm
behalf.
not really interested in taking testimony from you, but thank you. Sir, with that, and Mr. Quinn, you're still there, I see.
Yes.
Would you like to say something? I mean, all I'm asking is, although of course it's a legal question, I understand you're not trained in law, what the reason is, legal reason is, why the bond should be waived. And that means what defense, if any, you have to the summary process action.
No, she does. She does.
I can't see.
I'm owed money for work.
Okay.
I'm owed money for work done here, Your Honor. And also, I'm currently out of work. I felt I can't do this, Your Honor.
All right. When you say you're owed money for work, Mr. Quinn, you mean for work done on the premises, owed money by Ms.
Yes, sir.
Gassett?
Yes, sir.
And do you know if you said this to the judge in the trial court?
No, I
Okay.
spoke with her before the first court thing, and she said that I shouldn't bring it up.
Okay. Wait, she said you should not bring it up?
Yes.
If you can't do more than this, Mr. Quinn, obviously I'm not going to ask you to do so. I appreciate your coming in and I appreciate your difficulty. I
Thank you,
really
sir.
do. I will
Thank
hear
you.
now from you, Ms. Gasson.
Thank you, Your Honor. So our position is, the facts of the matter is that Mr. Quinn has been a tenant of ours since August of 2019, where he lived here with his partner. At the time he signed the lease, agreeing to pay $14.50 in rent per month. We have not raised the rent since then. During the pandemic, his partner agreed to, he just decided to move out, and he wanted to sign a lease on his own. At that time he was employed, he agreed to pay $14.50 in rent. During the beginning of 2022, Mr. Quinn notified us that he was unemployed, and we informed him about how we could apply for raft assistance in order to obtain rent during the rental assistance during that time. Despite letting him know about that in the spring or in early summer, he didn't file for raft assistance until we commenced a summary process action. At that time, we did withdraw the summary process action when he did receive raft assistance for the months of June through November of 2022. Once December 22 came around, he no longer pay. He still continued to not pay rent, which required us to institute the summary process action against him. At the time, the tenant now owes rent or use and occupancy for the months of December through June. So that's seven months of rent that's owed. We received a judgment in the housing court for possession and for $6,130.57, which included rent, use and occupancy, interest, filing fees, and other costs. While Mr. Quinn was at the trial and during the housing specialist conference, he did not raise any counterclaims. He did not file an answer. He did not raise any defenses at that time. Prior to the hearing, I told him that he should speak with the lawyer for the day and the attorney for the day. Mr. Quinn was advised on all of the notices for the court that legal assistance was available through legal clinics or through the attorney for the day program. He indicated that he did work on the house, and I told him, well, we had never authorized any work on the house, and at that point I didn't see that it was relevant to this action, as we've never reduced rent or anything when we'd have ever paid him for anything around the house. He never invoiced us for anything, and again, when we went to both of the hearings, he didn't raise it. He appealed timely. We had a hearing on May 5th, where Mr. Quinn did not attend at that time. As a result of him not attending at that time, he had raised no defenses. Again, he had raised no counterclaims. He has not included anything in either the appeal, the notice of appeal of the judge's decision, or anything like that. There is a question about whether this appeal of the order is timely. I know that the order was it was on May 5th, docketed on May 10th. To my knowledge, Mr. Quinn did not appeal until May 19th, and I was notified on May 22nd.
Why wouldn't that be adequate? That's 9 days after docketing. Aren't there 10 days?
I believe it's 6 days we filed a motion to dismiss.
I see. Okay. I'll have to look at the statute about that.
No problem.
Let me ask you this. How much of what you've told me is in the record?
All of it is in the record, as far as everything about the rent and the lease, his non-payment of rent. The judge's decision was that he didn't contest the timeliness and service of the order, the notice to quit or the summary process summons and complaint. He appeared at the hearing. At that time, he said he suffered an injury at work and he wasn't feeling like himself. The judge asked him questions about why he was unable to pay the rent. So at that time, he didn't raise any defenses. He admitted that he owed all of the rent. That was
Did he raise this argument about if it's an argument about having done work on the premises?
No, he did not at the trial. In his appeal, he did write in the reason that he did work around the house that caused
I saw that.
The trial
Um,
didn't.
Let me ask you this. What is the amount of the appeal bond and what is the amount of the use and occupancy?
The judge found us, our judgment was for 6,130 would be the judgment. So that was the appeals bond at the time. We're requesting to add an additional 2 months rent and use and occupancy to the appeal bond in the amount of $1,450 per month.
Well, it's hard for me to make findings of fact about that. Of course, nobody's sworn and, so on. I'm allowed to take affidavits, but let me ask you this. I don't see anywhere, the order seems to say that the use and occupancy is the customary amount, right? What is that?
I think it was what was in the lease. So the lease is for $1,450 per month. Again, that hasn't changed since 2019. So when I opposed the motion to waive the appeal bond, I did request at least that if the appeal bond was waived, that Mr. Quinn at least pay use and occupancy in the amount that he'd been paying since he moved into the apartment.
Customary amount each month.
But I would argue that, again, I know that it's not in the record, but that it is below market rent and that the fair market rent for a 1-bedroom is over $2,000 currently.
You submitted comparables and so on?
I have not.
You have not, all right.
We didn't have a hearing at the time because Mr. Quinn didn't attend the hearing.
Okay. So I think I understand your argument, at least as much as you've told me. You have a few more minutes if you want, but I think I sort of have a picture of what each of you is saying.
Yeah, I would just briefly add that, my husband and I are small landlords. We only own, 1 2-family home that we use as an investment property. We're not a large landlord. Our mortgages, we pay $2,300 almost in a mortgage per month, which includes tax and insurance, and then our water bill for the property is $700 a quarter. We had a very good relationship with Mr. Quinn, and we enjoyed having him in the apartment. We have no problem with him, except that he's not paying rent. He can't afford to pay rent, and we can't afford to have him there. Unfortunately, we tried to work it out with him in the raft, and to get him to be able to find work, but he hasn't found work, and he's unable to afford the apartment. And I also just want to unequivocally deny that I informed Mr. Quinn not to bring it up to the judge. In fact, I told Mr. Quinn that I couldn't act as his attorney because I was an opposing party. But I would encourage him to tell the judge whatever he'd like to tell him. I told him that, in my opinion, if he felt he was owed money for where it would be outside the action of the rental matter, because we've never reduced rent. We've always accepted the full amount of rent for property.
All right. Well, you guys are not sworn, so I'm not going to swear you and try to figure out that whole piece of it. So I was thinking about a response, whatever, but you're not sworn, so it doesn't really matter to me. I mean, it matters, but it doesn't, this isn't a setting for taking that kind of evidence. All right. Thank you both, or all 4 of you, very much for coming in. And your arguments have helped me sort of focus on what has to be decided here. So with that, the case is submitted